Now, to cover the case here, to break it down, we have our legal panel, criminal defense attorney Bob Bianchi joining us live here. Bob, good to see you, and thanks so much for coming on. Good to see you back on this case here, or at least discussing it, rather. I want to ask you this. For viewers at home that may be watching, some may say this was clear-cut. The jury would have came to a verdict yesterday. They did not. They're on day 2 beginning at 10 a.m. Is there anything to read into that extension of deliberations?
We call it a fool's errand, Shaun. As lawyers, when we're sitting there waiting for a jury to come back, you can never anticipate it. In some cases that you think are so clear-cut, they could be out for days. In cases that are complex, they come back early. I think this jury is going to do its due diligence. I will say the jury instructions that were read to them were extremely convoluted. They weren't really presented by the judge well. The judge had to stop on a number of occasions. Significant pauses. I actually was saying to a colleague of mine, the judge should just scrap what he just said to the jury and read it all over again because it was so disjointed. But that said, they've got a number of counts they've got to deliberate upon. They've got to get to that self-defense. They've got to go through complex law. There's a lot of evidence. So it's not surprising to me if the verdict doesn't come down today or even tomorrow. But you just never know how the jury's deliberating.
All right, let's break this down for folks at home. Rittenhouse facing some very serious charges here, very serious case, felony charges, 5 of them indeed, with sentences ranging from life in prison to 12 and a half years behind bars, but they're on your screen there. You may remember the possession of a dangerous weapon that was thrown out, that was dismissed. But there are several on your screen. First-degree reckless homicide with use of a dangerous weapon, and so on and so forth. Do you think that Rittenhouse will be found guilty of any of these based on looking at the presentation from the prosecution and the defense? Does this go half and half, or does this whole thing swing in Rittenhouse's favor?
Hard to say. Listen, if they buy the self-defense across the board, that it was a reasonable belief given the circumstances that were going on, Rittenhouse, the thing that's getting me is they keep saying that Rittenhouse, the whole state's case was based on that he provoked the incident. But the law on provocation is very clear, and I think it's very important your audience knows this. It means that a person engages in unlawful conduct, the type of which could provoke an attack, and that he actually does provoke the attack. The evidence that came out in this case, even through the state's witnesses, was that he did not provoke the attack. The prosecutor wants to go on the fact that the mere idea that he brought a weapon is what provoked the attack. But Shaun, there were lots of people with weapons out there that did not provoke any kind of attack. So that was a very weak argument by the prosecution. If anything, the state's witnesses were showing that it was them that were pursuing Rittenhouse, not the other way around. So to answer your direct question, the prosecution blinked when they asked for the lesser included offenses. In other words, they gave the jury another option, not so that it's not just not guilty and then the highest charge, intentional homicide. They gave them this wiggle room and asked the judge to give them a lower charge, hoping that they would compromise perhaps on that middle charge because they knew that that self-defense claim was in significant jeopardy, and they wanted to try to give the jury something else to chew on so that they didn't have to come back with a straight not guilty. So there is a possibility the jury would compromise. We'll have to wait and see if that happens. But again, if they find self-defense and what we call a perfect self-defense, that it was Rittenhouse being attacked, Rittenhouse being screamed at, Rittenhouse having rocks thrown at him, Rittenhouse being on the ground when people are still pursuing him, grabbing his weapon, and they find that self-defense, none of these other charges make a difference. That's an outright acquittal.
What about when they added the FBI drone video? It seemed to be a last-minute ad there. Does that play any role in this case, and is it acceptable in the court?
Well, the court accepted it. The video came in late. But I'm not sure it really changes the facts here. I don't think the facts are really in dispute. There's so much video. There's so much testimony about what happened. I think what's relevant is, a video can't tell you everything. And I would like to have heard the defense argue a little bit more and a little bit more forcefully that this is an unfolding situation that's happening very quickly. Shots are being fired behind Rittenhouse. Rocks are being thrown. Like I said, all this activity is going on. And the fact of the matter is, was he reasonable to believe that he could not just die? And this is another point that I don't think the defense emphasized enough. But it also says self-defense could be used if there's great possibility of great bodily harm. So under those circumstances, I don't think the videos make any more of a difference. The people know
Okay.
what this case is about. It's going to come back to reasonableness only.
I've got 45 seconds with you. Talk to me about the jury. We've got to remember these are folks that are, it's of your peers, it's folks in that area. You've got protests outside. They are not sequestered. Is there any cause for jury intimidation here? Is that a worry?
I would be worried whether I was a prosecutor or defense lawyer here. We are now having trials by politics and demonstrations opposed to facts and law. And there's no question about the fact, we even had jurors in voir dire say it, that they were concerned about their safety because of the nature of this case. And it becomes unfortunate in the cases that I've tried that are high profile, the judges did everything they could to make sure protesters and demonstrators were nowhere near jurors in order to intimidate them one way or the other. That shouldn't be an influence, but unfortunately in cases like this, I'm certain it is.
Bob Bianchi joining us live here. Jury deliberations continue about 50 minutes from now. We will keep you covered. Bob, good to see you. Thank you.
My pleasure.
Turning now to one of the most watched trials in America right now. Closing arguments set to kick off any minute now in the Kyle Rittenhouse trial. The jury could potentially seek lesser charges. This in the deaths of Anthony Huber and Jason Rosenbaum. Joining us now is criminal defense attorney Bob Bianchi, joining us live. Bob, good to see you, and thanks so much for coming on. Major day there in Kenosha, obviously for Kyle Rittenhouse's family and so many others, the families impacted by what happened there in Kenosha back in 2020 in the summer. I'm curious to know, from a legal standpoint, what are you watching for today?
Jury charges, jury charges, jury charges. This is what it comes down to. It's not sexy, but it is what the law is that's read to the jury. And the prosecution blinked last week by asking the court to give lesser included offenses, we call that. Essentially, what that means is he wanted to give the jury more options for things less than first-degree murder charges, which would land a life imprisonment sentence. And the reason why you do that as a prosecutor, and having been a former homicide prosecutor, is that you're concerned the evidence wasn't sufficient to meet the charges. What the prosecutor did in this case, with all due respect, was overpromise and underdeliver. He even had his own witnesses on the witness stand. I host a show. I keep mentioning this, and I had to come on in the middle of a witness and ask my producer literally, did they take this witness out of turn? Is this a defense witness? Because it's supporting Rittenhouse's claim for self-defense. And they were like, no, that's the third victim in the case, Grosskreutz, who approached him, as you know, with a weapon in his hand. Yeah. So far, the witnesses for the prosecution have supported the self-defense claim. So what the prosecutor is essentially doing is going into that sliver. I predicted this a couple of weeks ago, where there's a second-degree homicide charge, which means the prosecutor saying the jury could potentially believe Rittenhouse honestly believed he needed to use deadly force, but that it was unreasonable nevertheless. And that drops it down from that first degree to second degree with only a maximum penalty of 60 years, at which he could get parole and be out much sooner than obviously a life sentence. That's why the prosecutor's fighting, so that the jury has a choice between either nothing, not guilty, or the intentional homicide, which they believe right now, in my opinion, they can't prove.
What about the point of the judge potentially ruling on a mistrial or mistrial with prejudice? Does that still happen? Do you see the judge going that route?
This is a tough one, and it's a strategic call by the judge. Look, no judge wants to declare a mistrial, especially in a case of this magnitude, after it doesn't benefit the families of the people who were killed and the injured. It doesn't benefit Rittenhouse. It doesn't benefit anybody to have to retry this case. So in a certain sense, you know, I've seen judges that have said, look, that egregious error about commenting on his post-arrest silence went over the line and was, the judge rightly indicating, was a grave constitutional error. But what the judge may wait to do is to see what the jury does rather than just dismiss a case. Because if the jury comes back not guilty and the self-defense is proven, the judge doesn't have to make the call on that motion. And in my opinion, what could also happen is if he is convicted, that motion can be resurrected or brought back up again in a motion for a new trial, and then the judge can make the decision. So I think he's reserving on that for strategic reasons.
Why 2.5 hours for closing arguments? It was reported that it was going to be lesser than that. The prosecutor asked for more time. I think about the 12 jurors. That seems to a point of exhaustion of 5 hours that they're going to have to sit through when they've seen the evidence, they've heard the testimony already. What are your thoughts on it?
There is no time limit for summations in my mind. I've given 2.5 and 3 hour summations in a complex murder case. So long as you're not repeating yourself over and over again. If the case has a lot of context, there's a lot of evidence, there's a lot of videotape evidence. So, I'm not particularly fond of judge limiting lawyers in terms of what they believe they need in order to be able to present the case. But look, 2.5 hours is certainly long enough. The jury will be given breaks. The jury will be attentive. That has been my experience. And again, I've given lengthy summations, and the jury has literally been watching every single move. So it doesn't come down to a time number. It really comes down to whether or not they're just not repeating themselves and they're actually making progress through the summation.
A final question is about Judge Schroeder. Obviously, he's been in the headlines. Depending on what news outlet you watch, there's support of him, criticism of him. I actually went and read a local court reporter's report. He's been covering Schroeder for a while, and he says this is typical of him and in his courtroom. Yet, from a national stage, he's really been berated. There are reports that he's received death threats as well and been called so many horrible names, etc. What are your thoughts on how this judge has handled this case and media?
I'm not a public commentator, a political analyst. I'm a legal analyst. And I have been in a courtroom where, first of all, you have to understand this judge has a reputation for being this way. So apparently he's not doing anything different than he normally does. But I'll tell you, I thought he was staid. I thought he was calm when he went after the prosecutor with regard to the egregious violations that the prosecutor did, including violating a court order about the admissibility of certain evidence. So what judges do in situations like this is they spank the lawyer in first outside the presence of the jury. And if the lawyer continues to do it, they start to spank the lawyer in front of the jury as a way of kind of saying, stop doing this. I've been surprised that even on my own social media that, some of the things that he's done, or wearing the tie or the ringtone, the veteran thing was a little wobbly, but I don't think that he meant to do it. It certainly is not anything of a cause of reversal. So I think the judge has tried to comport himself correctly. And what people are doing is looking at this from the prism of politics as opposed to the court of law. Nothing he has done in there with regard to his temperament has been over the top. I've seen a lot worse. And people should go into courtrooms every day that aren't famous and watch that happen day in and day out. So I don't get where this is coming from. And by the way, he gave the prosecution a big bone last week when he allowed them to argue that it was Rittenhouse that provoked the incident, because that would eliminate his self-defense claim. And there were a lot that argued, legal analysts on the liberal side and on the conservative side, that they didn't see that should be a charge that should be admitted. So it's all about his rulings. That's what makes a difference, not his temperament.
Yeah, and local court reporters reporting that he may surprise you in how level-headed when he comes out in his ruling is and what he allows in his courtroom, and then how he actually hands down verdicts. We will see today. This could be a chilling day. We'll continue to follow the case. Bob Bianchi following it as well. Bob, thanks so much. Good to see you.
My pleasure. Thank you.
Coming up, President